Consider, if you will, the profound constitutional rebuke delivered to Donald Trump by the Supreme Court just moments before the Christmas holiday. The headlines have circulated, but the jurors' credential significance warrants a closer examination. The court has ruled decisively that the current executive regime lacked the statutory authority to federalize and deploy the National Guard to enforce laws in the state of Illinois. The architecture of this decision is telling. It was a 6-2-3 ruling. One found Justices Alito, Thomas, and Gorsuch in dissent. Yet joining the court's three liberals in the majority were Chief Justice Roberts, Justice Barrett, and notably Justice Kavanaugh. The opinion is an exercise in textual precision. It declares that the Department of Justice failed to carry its burden. They could not demonstrate that the statute in question, 10 U.S.C. Section 12406, subsection 3, permits the president to seize control of the National Guard under a nebulous claim of inherent authority to protect federal personnel and property. However, the true intrigue lies in the margins, specifically in a concurring opinion authored by Justice Kavanaugh. In a footnote, he engages in what can only be described as a frantic attempt to revise his own judicial history. As observers have noted, the justice appears to be insisting that immigration enforcement under his watch should not resemble the very thuggery that the Trump administration has made its hallmark. Allow me to read the text of this footnote, for it carries implications far beyond the immediate case. While the central ruling prevents the irregular deployment of the National Guard, Kavanaugh writes the following. The state and the government disagree about whether immigration officers have violated the Constitution in making certain stops and arrests. He continues with a sudden reverence for civil liberties. The basic constitutional rules governing that dispute are long-standing and clear. The Fourth Amendment requires that immigration stops must be based on reasonable suspicion of illegal presence. He adds that stops must be brief, arrests requires probable cause, and most remarkably, that officers must not make interior immigration stops or arrests based on race or ethnicity. This is an extraordinary statement from Justice Kavanaugh because it stands in stark contrast to his decision from September 8, 2025. One might recall that when California and other states argued that ICE and Border Patrol were targeting communities based on race, the lower courts blocked those actions. Yet Kavanaugh, speaking then for the court, essentially vacated those protections, allowing what became known as Kavanaugh stops profiling by another name. To understand the magnitude of his retreat, recall his reasoning in that September opinion. He argued that reasonable suspicion depends on the totality of circumstances. He explicitly listed those circumstances: a high number of illegal immigrants in Los Angeles, their tendency to gather in certain locations for work, and their employment in industries such as landscaping, agriculture, and construction, jobs that do not require paperwork. He even cited the fact that many in the area are from Mexico or Central America and speak little English. He took the demographics of a majority-minority state and the realities of the labor market and twisted them into a license for the executive to target individuals based on who they are and where they work. Yet now in this holiday decision tucked away in a footnote, he pivots. He joins the majority to say there must be a fact-based analysis of whether the National Guard constitutes regular forces. He concedes the Trump regime's actions in Illinois would be unlawful. He attempts, it seems, to distance himself from the very machinery of profiling he once helped assemble. One might surmise that Justice Kavanaugh, perhaps in the spirit of the season, decided he no longer wished to play the role of the jurisprudential villain. The lengthy footnote we examined is appended to a decision where he agrees with the court's majority on a crucial statutory point that the term regular forces encompasses the military. It is a conclusion he seemingly plucked from a single amicus brief, yet it allowed him to pivot. His concurrence reads almost as a plea for absolution. He insists upon his benign intent, yet the record is obstinate. The four factors he previously cited as grounds for suspicion: employment in agriculture, gathering in public spaces, residing in Southern California, were the precise criteria used by the executive to target specific nationalities. Now he retreats. He presents his newfound clarity as if it were ancient wisdom, writing as though the rules against racial profiling have always been inviolable in his mind, conveniently ignoring his own recent jurisprudence to the contrary. But beyond the curious case of Justice Kavanaugh, the court's broader behavior demands attention. This ruling arrived via an emergency motion, a procedural vehicle the administration has exploited successfully throughout the year until now. They end the year not with a coronation of executive power, but with a rebuke. The significance here cannot be overstated. The issue was not merely whether the president could station the National Guard in Illinois or Texas, an act that itself would have flirted with tyranny. The true peril lay in the administration's argument for total difference. Their contention, maintained until the final hour, was breathtaking in its audacity, that if the president declares a rebellion exists or defines troops as regular forces, that declaration is final. End of story. Had the court accepted this logic, had they granted the executive the deference it demanded, the president would have possessed a blank check. He could have utilized emergency powers for any number of pernicious ends, including the disruption of elections. The stakes were nothing less than the architecture of the republic. One interpretation is that this court, generally sympathetic to executive vigor and conservative policy, peered into the abyss. They realized that to greenlight this specific claim would be to sign the death warrant of the democratic system. Thus, they issued a decision that was textual and solid. They engaged in the pedestrian but vital work of statutory construction. They determined that regular forces includes the military, a counterintuitive reading perhaps, but one grounded in deep research. Rather than rushing to judgment in a few days, as is typical for emergency applications, the court deliberated. They requested supplementary briefings. They took a month, and in doing so, they delivered perhaps the most consequential opinion of this second Trump era. They have shattered the presumption that the president's invocation of an emergency acts as a solvent upon the rule of law. Yet now, in this holiday decision tucked away in a footnote, he pivots. Justice Kavanaugh's reticence to speculate on the future is understandable, for the administration retains one final draconian instrument, the Insurrection Act. They have thus far eschewed its use, likely recognizing that the political price of deploying the American military against American citizens would be ruinous. Yet, should they choose to cross that Rubicon, the Supreme Court has now made it abundantly clear that a legal confrontation will ensue. The court has refused to prejudge whether domestic military policing violates the Pars Comitatus Act, ensuring that any such move remains legally perilous. The administration effectively finds itself back at the starting line. Their strategy to militarize law enforcement in Portland, Los Angeles, and beyond has been stymied. They cannot plausibly argue that regular forces are insufficient when they have not yet attempted to utilize the army through lawful channels. They are left with a stark choice: invoke the Insurrection Act or retreat. To claim, as they might, that the unrest in a city like Portland rises to the level of insurrection under the statute is an absurdity that the American public would likely find difficult to swallow. And even if they proceed, the court has signaled that it will not stand idly by. It will adjudicate the legality of that decision using standard judicial methods rather than bowing in blind deference to the whims of the executive. This decision is in a sense a hidden warning. For too long, the court has permitted the executive to expand its power under the flimsy pretext of national security. As we have seen with this president, if you grant him an inch of latitude, he will seize a mile of authority. He has treated national security not as a serious concern, but as a universal solvent to dissolve any legal impediment to his desires, be it regarding wind energy or border policy. The court's ruling suggests a limit to this indulgence. They seem willing to tolerate a certain degree of executive overreach, what one might call authoritarianism light, but they have drawn a line in the sand against the full dissolution of the constitutional order. They will not permit the transition to a fully authoritarian state. The Constitution is not a suicide pact, but neither is it a permission slip for tyranny. The most salutary aspect of this decision is the judiciary's reassertion of its own prerogative. It is the court, not the president, that will decide whether an insurrection exists. It is the court that will define the meaning of regular forces. This restoration of checks and balances is the holiday miracle the Republic required. If you value this kind of rigorous analysis, I invite you to subscribe to this channel and support independent journalism. Join us as a member to ensure we can continue to scrutinize the exercise of power and defend the principles of our democracy. Thank you for watching. Yet now, in this holiday decision tucked away in a footnote, he pivots.